It's Patriot Smoothie. Happy afternoon. It was a morning of intense legal arguments here at day 10 of the trial for Tamara Lich and Chris Barber. Lots and lots of arguments. Lawrence Greenspun making his reply on behalf of Tamara Lich to the Crown on the admissions to argument, citing quite a few different things. There's quite a lot to go through there. But before we get into it, if you'd like to support the work we're doing, feel free to send me an e-transfer at realpatriotsmoothie@protonmail.com. And that helps us a lot as we continue to do this work. This morning, probably the heaviest day in court so far out of all 10 days. Lawrence Greenspun very fast on his feet, very accurate, and he came well prepared to make his argument this morning. Just incredible amounts of information to process. So if you want more of the specifics, go on to my Twitter thread or my X thread, sorry, and you can see that there as I chronicled the paraphrasing of the debate as it was happening in court. A lot of specific information. A few things I may have gotten wrong here or there. For example, I think I accidentally called the judge Justice Heather Perkins McVeigh. It's Heather Perkins McVeigh. Small things like that. Again, a lot of the arguments that Greenspun was making surrounded the when and the where, not the when and the why or something. So when I'm saying why, that's not really what's being talked about in court. Again, so as we're talking about this case here, the essence of the argument that Greenspun made is that the counts that his client has been charged with, for example, count 1, which is counseling mischief not committed. So the mischief has not been committed, but they counseled it. The reason that they're not that it's not committed for that is because if it was committed, then they would be a party to it, and that would change the dynamics of trying to prove the counseling and wouldn't be able to do that. But also in count 6, they're literally actually charged with mischief. So the Crown is both saying in their counts that there was mischief not committed, and then that the accused committed mischief. So we've got the like both worlds going on here, trying to go down the same hallway at the same time, where on one count you're saying, okay, counseled mischief not committed, and then on the last count you're saying, okay, here's the mischief you committed. It's hard to say, but again, there's legal reasons why they need to phrase it that way. It's a little bit odd. I actually asked Lawrence Greenspun himself just a moment ago if that was regular, if we see that a lot in court when they're trying to do counseling charges for things not committed. Like I believe also count 2 is counseling intimidation not committed. I believe that it's phrased the same way for the same reason as the first one. So is that if it was committed, then they would be a party to it, and therefore you can't counsel something in that way. It's very hard to wrap your head around. I know I can't begin to say I understand why it's phrased that way, but the fact is that we have a count that says that it wasn't committed, and then count 6 of the information is you did commit mischief. So which one is it? It has to be one or the other. To quote Greenspun, it has to be one or the other. It can't be both. So that's one problem, but that's not where the majority of the argument focused on. Again, this admissions to argument all goes back to the 9 witnesses the Crown intends to call. 9 of their witnesses, now 8. There's 1 witness that the Crown has said they will not call in that original 9 that we've been talking about for weeks here. And the argument that the defense is making in essence is that their admission that the enjoyment of property was interfered with basically makes any testimony that any of these witnesses could give irrelevant. And then Greenspun elaborated and went through the different counts, and basically, they don't have information on counseling of mischief not committed because they never had any contact with Tamara or Chris. They never met either of them. They don't know them. They didn't, and for all the information, again, the same problem. Greenspun circling back to something the judge said a while ago when the judge asked the Crown, what specific information can these witnesses give the court in regards to what time did something happen during the day? For example, at a corner say a corner is blocked, Laurier and Elgin, for example. Okay, on this day, at this time, was it blocked by how many vehicles, so on and so forth. There's no specific information, just general information. And again, it all kind of boils down to very the weight, as the word is used, the weight of those observational arguments are very observations are very low. In fact, the defense says that they're community impact statements or impact statements that should be withheld until the time when they become appropriate, if and when there's a conviction, when then they would be more appropriate to give impact statements. The judge saying that no, she'll gatekeep, she'll exercise her powers of trial control to keep things on the rails, as she likes to say, but then the defense saying that she doesn't need to do that because Crown, in citing a bunch of case law that basically the judge is within her right to make a decision on this matter because discluding these witnesses will not preclude the Crown from calling any other witnesses, and it will not cause irreparable harm to the Crown's case, which is the condition on which the trial judge would not be able to exercise those powers. powers if it caused irreparable harm to the prosecution's case, and that's not what's going to happen as a result of this action. The defense made that case fairly clearly and said, you know what, these people are giving impact statements, general statements with very little observational weight. It's not probative, as the word they like to use, enough to be of significant legal relevance, and it's impact statements. They don't have, as the judge asked weeks ago, they don't have specific information day by day, hour by hour, truck by truck, which license plate was doing what, when, where, and why. You know, they don't have that information. They have a general statement. My street was blocked at such a place, or I was harassed by 5 people, but I don't know who they are. I can't tie them to the Freedom Convoy, and so on and so on and so on. So what is the value of these witnesses? Are we at 5? What are we?
540.
Okay, so we're just going to wrap up here. That's the defense's essence, from what I gather, is that the legal value of these 8 witnesses now, their testimony, there's no significant legal value to it, in the sense that they've made an admission that there was interference of the enjoyment of property by some individuals at the protest, and therefore any kind of general testimony saying, okay, my property was interfered with, isn't relevant, and they can't give any more specific information. For example, to the common unlawful design for the Carter application, they don't have specific information of times and places. So it's a matter of impact, and it's a matter of basically just general observations. It's not specific enough to be legally necessary, is the defense's argument. Now, Justice Perkins McVeigh saying that she will not be making her decision on the admissions 2 argument. This is the response. Eunice also giving a response, much of the same language. Heavy and much legal citations there that Eunice and Greenspan walked through the court with. The judge said that she'll try to make a decision on this by the end of the week. We did get into the next witness, which is Kim Ayot, General Manager of Emergency Services and at the City of Ottawa, every service except for policing. And basically he came to court today without his notes. That was a big thing. He was asked to leave the courtroom. There was discussion, the Crown saying that they have a copy of his notes. Miss Magus for Barber rising and saying, you know, this is a frequent thing that's happening with the signal chat, with whatever. It's not an issue, as the Crown says, of them meeting a disclosure request. It's a disclosure obligation, and that this goes back a long time ago, that the Carter application is a moving target, that it only crystallized last week, that they're dealing basically on their feet, moving around and trying to orient themselves to which direction things are actually going in. So we'll see what happens, but Kim Ayot, I assume after the break, will be coming with his notes that he actually made, and we'll see how that goes. So follow along on Twitter, on wherever you follow, if you want more information. Thank you so much for supporting the work we're doing here on Patriot Smoothie from Ottawa, on wherever you're watching. Have a great day.